Yes, yeah, he's not on swearing in.
Good morning, Mr. Crouch.
Good morning. May it
You're
please-
having a busy week.
I am, Your Honor, and next week is looking to be just as busy. May it please the Court, Andrew Crouch for Mr. Rosado. Mr. Rosado appeals from a single conviction for failing to register as a sex offender out of the Boston Municipal Court. In this case, the facts are largely not in dispute. What is in dispute is how the sex offender registration law should be interpreted, and specifically how it should be applied both to Mr. Rosado and to homeless sex offenders. The facts of the case are pretty straightforward, and I won't belabor them. Mr. Rosado is a sex offender, convicted sex offender, living in the city of Boston.
Does the defendant still remain a homeless person when he lists the Pine Street Inn as his residence?
He does, Your Honor. He does. And that is a point that is central to the debate. The statute, the sex offender registration law, and the board's own regulations do not define the term homeless. They don't define residence. They don't define address. This causes some problems. But Mr. Rosado, in providing a temporary and approximate location, does not forfeit his status as a homeless person. He just is trying to provide some sort of an address, some sort of a location, so that the board and the police department have a better chance to
As a
locate him.
factual matter, was the defendant at the Pine Street Inn the night that he signed the form?
The night that he signed the form, it looks from the record that he was not there on that particular night. Now, as Your Honor knows from reviewing the record, the Pine Street Inn, as a homeless
As a
shelter,
lottery.
is not a shelter for which there is a legal entitlement for any individual particular person. It's based on a lottery system. There isn't any evidence of the people who are the men who are turned away, only the individuals who get beds.
When you say, in response to Justice Cowan, that when he signs that he's Pine Street Inn, he doesn't lose his status as a homeless person, is that, but you say there's no statutory or regulatory provision dealing with that. So when you answer yes, what is that based on?
It's based on, I would recommend, I would advise the court to take a look at the 16L letter I provided in this case some months back with some of the materials.
I think I've read all of those, if they all came in with the one June 22, if they were on one thing. Mr. Crouch, it seems to me that our legislature, maybe unlike some of those cases, was actually trying to recognize that there's a homeless problem.
Certainly.
I don't think there's any question that residents, and those courts seem to be, and I didn't have a chance to go and compare the statutes, but they didn't seem to have a provision for homeless people. Am I correct?
Most of those, my recollection is that those statutes did not provide it.
It's Wisconsin and Maryland and
Washington State.
And they've all said you can't convict in these circumstances, correct?
Correct.
So the question that occurred to me was that here you have the legislature actually recognizing that there are homeless people, but obviously a homeless person, almost by definition, doesn't have a residence.
Correct.
It seemed to me that at least you could infer that this particular homeless person was at least trying to say, this is where I might show up if I'm lucky enough to get a bed.
And that is exactly actually what the trial judge who sits in the jury waive session notes. He says, notes the paradox that is posed by the Commonwealth's interpretation of the statute. And that paradox is central to the case. And it is that in this case, Mr. Rosado, as a homeless sex offender who does, at least in good faith, try to provide the approximate location where he spends the most of his time, he suddenly falls under prosecution, whereas the judge notes if he had simply written homeless on the form, provided no address, completely thwarted the purpose of the statute, which is to provide a better opportunity for police to locate these individuals, he couldn't have been prosecuted.
I thought he
because
had to
would
put
just be homeless.
the approximate location in the city where he was. That's not homeless. You'd have to say South End, North End.
The board's own regulations and the statute do not, and it's an important point, do not require a homeless person to list any address. The old
Just
statute.
has to show up at the police, he has to
every,
come.
every 90 days under the old law.
He would
That's a
have been
special
vi-
provision for homeless persons.
That
They have to
is.
show up every 90 days in person at the police
Because the
station.
legislature does understand that tracking homeless people does provide, does pose
Am I reading in
specific
this
problems.
form,
Client-
am I reading something wrong that says if homeless, he must provide the city an approximate location within the city?
That is something that is in the board's instructions.
Yeah, well, I know it.
The board's, it doesn't come from any other particular source, but it does recommend that they provide an approximate location.
Well, maybe
Just recommended, it says they gotta do it, must provide.
maybe he was doing that. I mean, everybody knows, every homeless person, I will take almost judicial notice that every homeless person knows that the Pine Street Inn is in the south end of Boston. It is not in, Melrose, and it's not in Charlestown. It's in the south end of Boston. So maybe he was doing just that.
In an answer to Justice Gray's question, I think that is indeed what he did.
I'm trying to help you out here. Now, was he showing up every 90 days?
Every 90 days, he
Absolutely.
routinely, and the judge noted that, he actually made a bit of an odd finding, which is that I don't find that over a period of time that you have been trying to purposefully evade complying with
He
the law.
hasn't been. He's been.
Every 90 days, like clockwork, he shows up.
Would your client have been better off if he had just listed himself as homeless?
Yes.
No,
Well,
wait
it's-
a minute. Because the board, correctly or incorrectly, has said, as Justice Glaney said, you must put
Providing-
down something. Now, maybe a homeless person knows that there's a difference between a constitution, a statute, and a regulation, but even if he does, if the regulation isn't being challenged and it says you must, he must.
In terms of that instruction, and as the
Yes,
Chief
but
Justice notes,
then the Commonwealth couldn't have prosecuted him for failure to be at the Pine Street Inn.
Correct.
If he would be better off if he had just said homeless, approximate location, South End, or whatever streets
Yes.
he wanted to put
He
down.
would've
Then
been.
he could not have been prosecuted by means of these records that show that he wasn't at the Pine Street Inn
and
all
that
these
would have
nights.
undermined completely
The entire prosecution.
the purpose of the law and the
Okay.
prosecution.
But I have another question for you. If you think about the purpose of the law, the Commonwealth, the legislature has determined, needs to know where these people are, these homeless people who have been
Yes.
designated sex offenders. So then they have to have this information according to them. So then, so how do you answer that?
I think that there is perhaps here a gap in the law, and what the cases, the out-of-state cases that I cite in that 16L letter, all address that where there is a potential gap in the law, it's an issue for the legislature, and I think that is something that a decision...
Okay, what is the gap?
The gap here is that there isn't an actual, as the Commonwealth did argue at trial, and I argue against that in my brief, there isn't actually a requirement that the person be at any specific location at any specific time, especially at a
Well,
shelter.
you can't require that of a homeless person. I mean, that's the definition
Yes,
of a homeless
I agree, and so that is the challenge here. Is that I think the legislature has thought it through to some extent. Says every 90 days, and now every 45 days under the new law, you have to report to the police station. I think that provides a better opportunity for. It does address the issue of the
But it seems to me they've done
homeless.
it, I mean, if they're going to do it at all, they've done it in a fairly sensible way. Every 90 days, every 45 days, give you a city and your approximate location. What more can you
Have they
ask
said
of a
give you
homeless
approximate location?
I'm sorry.
Have they said give you approximate location?
That only shows up in
No,
the
that's-
board's,
Regulation.
the board's
Okay.
instructions.
Okay.
So they've just said, go to the police station every
90 days.
every 45 days.
Or now it's every 45
And I assume the
days.
police might say,
But every time you go to the police station, don't you have to fill out the form?
You do have to fill out the form every
So
time.
you have the instructions,
And you have the instructions.
which
And I-
say in place of, if you're homeless, where it says permanent address, provide the approximate location within the
Correct.
city.
And I think the argument here is that, first off, under even the strictest interpretation of this situation, Mr. Rosado does indeed comply with that. He provides to him as a homeless person who, by its definition, that condition is the lack of a permanent housing. The Pine Street Inn, where he has been before this case started and since this case started, he is actually still registered there. That is to him the most permanent approximate location that he can give.
Do they keep his mail?
There's nothing in the record, I could comment on that, but there's nothing particular in the record about that. But the mail there, when the officer testifies about his attempt to locate Mr. Rosado, he simply makes a phone call to the inn. They say he's not there at that moment because actually he calls during the day, during which time people are removed from the homeless people actually have to leave.
Wasn't there something about, didn't the Pine Street Inn return something as undeliverable?
Correct.
So that would suggest they don't keep his meal.
That would indeed, actually, Your Honor.
Well, is it in fact, does the record indicate that it is that they have a particular policy in that regard? Like if the person isn't there for 2 or 3 days, they return it?
It doesn't.
Or do they return it, I mean, for all we know, they return it immediately because there is no such thing as a permanent resident here.
And because there is no legal entitlement to be there from day to day, I think there is a
construe-
reasonable inference to be drawn there.
If we construe what he wrote down, which I think was 444 Harrison Avenue, as, quote, the approximate location where he was, because somebody said we know where that is, he's home free. He's complied, right?
Correct.
Well, let me ask you this question, though. What was he convicted of?
This is the question. This is one of the other key questions, and this is very confusing because it's not at all clear, which is why the brief is a little bit scattershot in its approach. There are potentially 2 theories under which he was convicted. The first one, failing to advise the board 10 days in advance of a change of residence or a change of address is one potential. Another one is providing the board false information. That theory would be that he wasn't at the location that he says he was going to be at. I think both of them, the first one in terms of changing residence and changing address, I would advise the court to look at those out-of-state cases. By the very nature of homelessness, he doesn't have a residence, doesn't have an address. And those cases find that you can't change something that you don't have because
But
you're homeless.
if we define, as Justice Graney suggested, the 444 Harrison Street as his approximate location, then there'd be no failure to provide a change of address because there was evidence that he was there sometimes after that. So there's no change of
Correct,
address.
and there would be
period.
insufficient
and
evidence
false
on that point.
information then goes by the boards the same way.
Yes, Your Honor.
So that
There would be
in effect, if we construe that as his approximate location,
He is in compliance
he's in compliance.
with both the spirit and the letter of the law.
I think one could almost, again, take judicial notice of the fact that the Pine Street Inn requires people to leave in the morning.
Yes.
That's in the record.
And it is.
And in order to be admitted in the evening, it's usually on a first-come, first-served basis.
Well, actually, a lottery basis even. So even if you are the first person, the probation officer at some point suggests that Mr. Rosado should comply better with the statute by showing up earlier. That's not what Mr. McDonald, the Pine Street Inn's director, says. It's a lottery basis. So even if he's the first there.
But we know that people who want to gain access that evening tend to stay around in that neighborhood, or some of them do anyway.
Or at least have some connection there, and especially there is evidence in the record that he does return there. He is, by his definition, homeless. He does not have a home. He has no legal entitlement to be there. But he does return with frequency to that vocation. So he is attempting to comply as best he can. I think that there is some vagueness and confusing nature about if that is not compliance, about what compliance actually is. And it's very important for this court. It's important for this court to make crystal clear to these offenders, especially since the legislature has decided to remove the protections that were previously there, the reduced sentences. Those have now been taken out of the statute. This is a quagmire for homeless people in trying to determine how to comply. And in this case, I would argue that even under the strictest interpretation, Mr. Rosado does everything in his power to comply, tries to routinely comply, and the judge finds that.
I take it, Mr. Crouch, that one way to resolve this would to say that all that is required of a homeless person is that he or she appear at the police station every 45 days.
And leave it to the legislature if they require something, it requires something further to make an amendment in the law, yes.
Because by definition, if one says even the south end of Boston, and then it turns out that the person is found walking on, let me just say, Stewart Street, which is very close to the south end, but I'm not sure what the south end of Boston is. In theory, he could be convicted if he had put down the south end of Boston.
If
he puts Boston and he's over at Kendall Square, I mean at Kenmore, he's violated something. I mean, the fact of the matter is that homeless people move around because they don't have a permanent residence.
Correct.
Well, he wouldn't have violated anything if he's just elsewhere in the city during the day. I mean,
he's got the right to free travel as any other person does, and as I noted in the brief.
But if he puts the south end and then he's observed, maybe he's now
sleeping, say, in a...
Or hanging out at a
I
homeless
think,
shelter.
I think you would be allowed to hang out, as Justice Cordy
Oh, no,
notes.
but staying there most of the time.
Correct. And I think that there would be some concern, but I think the statute as it is written only requires him, or the only instruction that we see is to provide the approximate location. He does that. If the legislature requires something more, it should make an amendment. But this court, I would strongly urge it to come up to have a definition that is clear for homeless offenders so that they don't get caught in the system, which then looks at a 5-year prison sentence for a second offense, substantial penalties.
No,
here.
he is a bad dude. He's a level 3, right?
He is a level 3.
Which
but
is the worst.
He is taking that responsibility. He is routinely registering with the police department. He is doing that continually. The legislature has provided now 45 days.
Essentially, Mr. Crouch, what you're saying is, what can I, an attorney, tell my client what they should do?
And I would, yes, Your Honor. And if the Commonwealth's interpretation, as it stood at the trial and through the board's witness, Mr. Thomas, is the one that prevails, you're going to find defense attorneys and CPCS-related attorneys advising their clients, as Justice Cowan noted, to simply write homeless, disappear into the system in a particular city, and become completely untrackable. And I think that that is an interpretation that is not in any way consistent with what the legislature's purposes were in drafting the sex offender registration law.
Thank you, Mr. Crouch.
Thank you.
Mr. Callahan?
Good morning, Your Honors. If it may please the Court, Michael Callahan on behalf of the Commonwealth.
Why can't 444 Harrison Avenue be interpreted as the defendant writing down his approximate location?
Because he put it down as his permanent address. And if
But,
in the
Mr.
record,
can I just ask you this?
But
Mr.
it's by definition it can't be a permanent address because since it has a lottery system, nobody can be there permanently.
And he must surely have known that.
he should have known this. This is something
No,
that
he knew it. He knows he's not entitled to a bed there every night because no one is.
Well, the individual that appeared as a witness for the Commonwealth, Mr. McDonald, stated that there are people that do stay there night after night. And
Well,
it's
because
for-
if you're fortunate enough with the lottery.
I believe he said there's an application process, and that Mr. Rosado did not.
So are you prosecuting him because he,
Filled in the wrong box?
yeah.
No, because he put in wrong
Filled
information
in the
a
wrong box.
Excuse me?
He put it in the wrong box.
He did put information in the wrong box, so now we don't know.
You
The
don't
board is
disagree
under the-
he's homeless, right?
Excuse me?
You do not disagree he's homeless?
He is homeless. And that's
You
why
do
he was
not disagree that he reports every 90 days or every 45 days?
He has.
Is this really something you need to prosecute?
Well, at the point in time, he's putting down a permanent address.
In the
No, he's
city
not.
of
He's
Boston,
filled
this
it in
is
the
what you
wrong-
need to in the city of Boston, this is what you need to prosecute.
To track level 3 sex offenders, someone who's been
But
convicted of
if
a.
he's
Homeless?
put down that he's homeless and that the Pine Street Inn is his address, what more can you expect him to do? What if he put a bridge? Would you be better off? And sometimes he was at the bridge, and sometimes he wasn't. You would have no records to ever find whether he was under that bridge or not.
Well,
He didn't put down that he was homeless.
no, he never did put down he was homeless.
Well, of course, there's no place on the form to put that. If you
Well,
look at the
there's
instructions,
no-
it says
there's
for
no
permanent if you look at the instruction, it says under permanent address, if you are homeless, just put a location in the city.
And it
It
says
doesn't
the
say
same-
describe yourself as homeless and put a location, it just says,
Yes, and it says the same for temporary address as
yeah,
well.
so it's confusing.
Temporary address is all out of state. For homeless, it doesn't say put it in the temporary. I mean,
But
can we just agree that he put it in the wrong box?
He did put it in the wrong box.
So
The
he
op-
faces if he does this a second time, he faces 5 years of incarceration for putting it in the wrong box when he has complied with what the legislature seems to have carved out, unusually in Massachusetts, a special provision for homeless people that he appear every 45 days.
Well, actually, at the time, the legislature had mitigated this difficulty by, or foresaw this as an issue, and it was a 30-day in the House maximum.
But why
Or, excuse
doesn't,
me, no.
why doesn't the application form simply say,
Homeless.
question number 1, are you homeless? If the answer to that question is yes, put down where you can be found, the approximate location where you can be found most of the time. And then question number 2, what is your permanent address? Wouldn't that have solved the problem here?
Perhaps, but that's not
Wait.
the way the form was
Yeah,
because it doesn't-
presented to him at the time.
But that's the problem, Mr. Callahan. Sometimes all of us have been faced with a circumstance where our precise situation isn't categorized. And so we face the problem of either doing nothing, and as far as I can see, he's given all the other, he's ticked off that he's level 3, he's given his name, he's given his social security number, he's given his race, he's given his tattoos, he's given his height, his weight, his probation officer. Are you registered? Yes. I mean, he's done everything accurately, and he's confronted with a form that doesn't address his circumstances. He doesn't, by the way, put Pine Street in.
Well, on that day, he did not have a probation. On August 17th, he did not provide a probation officer.
When he showed up at the police station every 90 days, did somebody say to him, "What are you doing here?"
The probation officer is Mr.
When
Arecibo.
he showed up to register every 90 days, did somebody say, "What are you doing here"?
Well, they begin to fill out this form.
Okay, so does somebody then write, he says, "I'm homeless," so why don't they write homeless at the top of the
Well, that's a question of why he didn't put homeless. An individual, Mr. Corey Thomas from the Sex Offender Registry Board, testified, and indicated that homeless people should be pointing on the top homeless and then an approximate
But
area.
isn't
located.
that the place to put it? But putting 444 Harrison Avenue, isn't that the equivalent of saying, "I am homeless"? Who else stays at the Pine Street Inn other than homeless
But he's
people?
also supposed to be putting true and accurate information. He hadn't been there in 10 days and wasn't going
10 days?
until August 30th.
The problem with August is that quite a lot of homeless people don't need to be indoors in August. Correct?
Correct. But when you're a sex offender and you put that as a permanent address, you should
But
be
he's
going
putting
there.
it as a permanent it's
sorry.
all very well for the person from the Sex Offender Legislation Board, and believe me, they do a terrific job trying to make sense of the system. But it's one thing for the sex offender legislation person to say, "I'm going to put homeless." I mean, I don't know if you'd gone to a CPCS attorney who said, "Look, there's no home thing. He's not out of state. I don't have a temporary address because I'm not moving everything else. I don't have a mailing address." He says, "No mailing address," correct?
Great. He
It's
puts a line
not a
through it.
mailing address.
He puts a
Line
line.
through. I don't have a mailing address. No mailing address. Don't mail me anything there. If you're looking for me, the chances are that you will find me in the vicinity or at 444 Harrison Avenue.
And the detective that testified indicated that upon his investigation that the letter had been bounced back, that
Don't
the
mail me
individual was
anything
not
there.
there.
Don't mail me anything there. I've told you I don't have a mailing address.
Okay.
I've told you affirmatively I don't have a mailing address. Please don't mail me anything there. Correct?
Correct.
Okay. So the whole prosecution was triggered by a returned piece of mail.
The investigation was triggered by the returned piece of mail.
Did the record tell us what the Pine Street Inn's policy was on mail?
It did not, the record is not clear on that policy.
But in any event, whatever the Pine Street's policy is, whatever it is, this man didn't think that he had the right to receive mail there, because he is telling the Commonwealth of Massachusetts, "I do not have a mailing address. I've put a line through it."
But I think it's fair to say that someone's permanent address is also a mailing address as well.
Absolutely not.
But if one interprets the 444 Harrison Avenue as the equivalent of "I am homeless," homeless people don't have mailing addresses.
Well, that's not completely accurate. My understanding is there are homeless shelters that do accept mail.
Mr. Callahan, let me put it this way. If permanent residences are where you receive mail, why does the board ask the question twice? It implies that you can have a place that you designate as a permanent address that is not your mailing address.
Correct, Your Honor.
Okay.
You could put same, quote, same.
You could put same, but if you can say, "No, it's not, and I don't have a mailing address,"
But in this instance, you have an individual who registered at previously had registered at a different shelter, and now he
That's
chooses
what
a different. This, I
that's
think,
what
shows the knowledge that he's now changing it, but he's not there.
well, he may be saying, "Most of the time, at the present time, that's where I'm likely to be." Who knows?
But he's not there most of the time.
He may or may not be. He wasn't there for the preceding 10 days.
23 days. The preceding 10 days and the following 13.
But he was probably not...
Doesn't this just create a situation where homeless people are almost bound to fail in terms of providing accurate information. If we accept the notion that homeless people don't have control of where they're going to sleep from day to day.
No, they can comply by putting that they are homeless in an approximate area of the city.
Approximate
And now
area.
it was at the time of this legislation, it was 90 days. Now it is 45 days.
Mr. Callahan, what advantage is it to the Commonwealth if he puts the south end, no mailing address, south end? And then it turns out that for 23 days, a whole 23 days, he's over in Kenmore Square or Central Square because, in fact, for whatever reason, one of his buddies is staying at that homeless shelter. We're going to prosecute a homeless person because he put down the south end and for 23 days he's over in Central Square where he happens to be getting a bed every night?
Yes, because it's inaccurate information.
Well, then he just...
He's supposed to inform when that inform the board, inform the police department.
Homeless
when
people
that
don't
is
know.
changed.
They know day to day. Let me put it this way. If the legislature has said the way we're going to track homeless people, sex offender registered who are not homeless, who have a permanent address, who have a mailing address, don't have to go to the police station every 45 days. Is that correct?
Correct.
So we're already putting a major burden on homeless people. Nobody's questioning that at the moment. You have to go to a police station. Many homeless people are drunk, they are alcoholics, they are, who knows, right? You impose that. It is the board that has said, we want more, correct?
Yes and no. In the legislature, I believe it's Chapter 6, 178F and a half, it says that they must provide accurate and true information.
Fine, so they're homeless. And the board, not unreasonably, says, give us an approximate. So if we're looking for you, we know to contact the Boston police or the Cambridge police. But we all recognize it can change from day to day.
Yeah.
Homeless people are free to seek out a homeless shelter any place they can. And indeed, what sometimes happens, I can tell you, is the Pine Street Inn may say, we are full, why don't you go across to whatever it is.
Well, actually, it was a probation officer that suggested that he go to the Pine Street Inn and try to, because they will send homeless people to other shelters, but they'll mark it on their sheet, the attendance sheet. And the individual from the Pine Street Inn indicated that as well.
I'm looking at this form,
Yes.
and if I'm Mr. Rosado, and maybe the instructions are attached, but I look at the form, it doesn't have anything that says that I write down homeless, right?
It asks for approximate address, correct?
No, it doesn't.
The
homeless
instructions.
a homeless person.
No, but
you're
I'm
homeless.
saying- you're looking at the form. I've got the form in front of me. It asks for permanent address. So if he was really smart, he'd just write none, right?
Correct.
Mailing address, none. None, 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 all the way through. Are you better off?
Well, at least now know that you're having trouble tracking this individual.
No, you're not. He's
Well,
complied with the statute. He's complied with the regs.
Well, now at this point, the board has an address that they believe he's at, which he's not.
Yes, could they find him through that address? Oh, yes, they could, because they go to the Pine Street Inn. We haven't seen him, but we think we can find you there.
If they had showed up on August 20th, 2005, they would not have been able to find him. He was
No,
not there.
he would not have been there, but the Pine Street Inn, I'm quite sure, might have had some information.
Or at worst, they could have just said, hey, when he shows up again, let us know. And he did show up again, and they would let him know.
10 days later, but
maybe.
the community's supposed to be on notice of where a level 3 sex
But if
offender,
he
an
just
individual's
written
been
none,
convicted
none,
of rape
none,
of a
none, none,
child.
the community's going to know nothing.
But unless you say that a homeless person can't exist, how can the police know where a homeless person is all the time? They can't.
Well, at least they will know who's homeless, opposed to just putting an address.
Know
They should
who's
be able
homeless.
to put they should be
Well,
putting
why
homeless.
isn't there a question that says homeless?
That's a question for the board in regards to the
May
form.
I ask you this? If part of our opinion, whatever we come out on, if we suggest that you put a place there on the form for the words homeless as part of their providing information, doesn't that make sense that a homeless person ought to be able to inform you folks that they're homeless?
It would make significant more sense, but the fact that they're registering every 90 days is usually triggering, or at this time, it's now 45
Just the
days.
same, the fact that they write down 444 Harrison Avenue signifies that they're homeless.
Well, to the layperson, it may not. I mean, we, as a prosecutor in the city, I know
Right,
that's
as a prosecutor,
that's
as a police officer.
To a homeless person, you know.
yes,
He's homeless.
correct. He is homeless, and he was tried as such, and he was sentenced as such, and that's the reason why he received the sentence opposed to the 6-month minimum that goes with a non-homeless person. But the facts are that he did put down on a permanent address. He did not verify true and accurate information. He changed the address from the previous registration dates. He also signed the box and checked it, saying that this is accurate information, also stating that he would give notice of a change of address. He checked it, signed it, and he said he understood it. He did not provide true and accurate information, and that's why he's convicted, and that is why Commonwealth is asking you to affirm the conviction. If there are no further questions,
Thank you, Mr. Keller.
Commonwealth is resting the remaining argument on his briefs. Thank you.